Alright, protection of employees, providing pipeline safety information, discretion of the against the employee with the general with the non-employee with the domain discharge with the employee with the otherwise discriminate with against the current with the former employee with the respect with the compensation term with the condition privileges employment with the employee or any person acting pursuant with the request of the employee provide cause for provided a cause to provide or about to provide cause to provide the employer with the federal government, including relating to any violation, alleged violation, any or regulation standard under this chapter of the federal law relating pipeline safety. Refused and gave the practice made unlawful the chapter of the other federal law relating pipeline safety. The employee identified with allegedly eligibility illegal ILLEGIALIT to the employer. Provide cause to provide is about with the provide cause to provide with the testimony of the Congress, federal, state, provide regarding with the provision proposed within chapter of the aim of the federal law relating to pipeline safety, commence the decommence the cause of the commence the about with the commence cause with the commence for the proceeding of the aim of the chapter of the federal law relating to pipeline safety proceeding for administrative enforcement with any requirements imposed in the chapter or any other federal law relating to pipeline safety. He provide cause to provide and appropriate to provide cause to provide with the testimony and proceeding described in some paragraph D. Have the assisted participated in about the participate in such manner such as the proceeding, any other manner in proceeding, any other action to carry out the purpose of the chapter, any other federal law relating to the pipeline safety. 2. The employer defined section. The term employer means the person owning and operating pipeline facility, contractor, subcontractor of the person. Department of Labor complaint procedure for the filing of notification. Person believe that they have he or she has been discharged otherwise discriminated against by any of the person by violation. Section A made no later than 100 days after the date of such violation occurred with the file of the person having the file on his or her behalf the complaint with the Secretary of Labor alleging such discrimination of the upon receipt of the complaint. The Secretary of Labor shall know for the writing of person in person named and complying with the Secretary of Transportation filing with the complaint. The allegations contained with the complaint, substance evidence support with the complaint with the opportunity that will be afforded in such the person in person on paragraph 2. Investigation preliminary order in general with no later than 60 days of the date of the receipt of the complaint under paragraph 1 after the forwarding of the person's name with the complaint and an opportunity to submit to the Secretary of Labor to written the response of the complaint with the opportunity to meet with the representative of the Secretary of Labor to present statement that witness the Secretary of Labor should conduct the investigation, determining whether the reasonable with the cover the belief of the complaint within the merit, and notify writing of the complaint with any of the person is alleged that they have committed the violation. Subsection A with the Secretary of Labor findings. The Secretary of Labor concludes that this reason covers the belief of the violation. Subsection A as Secretary of Labor shall include the Secretary of Labor findings. Preliminary order of the providing of the relief prescribed in paragraph 3B, no later than 60 days after the date of the notification of the findings, and under the subparagraph that any of the person alleged to have committed violation of the complaint made any objection to the finding of the preliminary order or both the request hearing with the record of filing such objections shall not operate the state reinstatement remedy with the containment of the preliminary order. Such a hearing that should be conducted expeditiously if the hearing is not requested in the 60-day period with the preliminary orders of the deemed final order with not subject to judicial review. B. Requirement showing with the complaint with the Secretary of Labor shall dismiss the complaint filed under the subsection and shall not conduct the investigation otherwise required in subparagraph A unless the complaint makes a prima facie showing the behavior of the described in section A with contributed to the fact of the unreasonable personal action alleged in the complaint, showing that by the employer nothing was seen with the finding with the Secretary of Labor the complaint that has made with the showing that under the required cause no investigation other requirements of paragraph A the conduct of the employer demonstrated with the clear with the convincing with the evidence of the employers would have taken the same unfavorable personal action in the absence of the behavior. 3. Criteria for the determination with the Secretary of Labor to determine the violation subsection A that has occurred with the complaint with the demonstration of the meaning of the behavior described subsection A was a contributing factor to the unfavorable personal action alleged in the complaint. 4. Prohibition relief with maybe or with the subparagraph A with the employer demonstrated with the clear with the convincing evidence of the employer would have taken the same unfavorable personal action absence for the behavior. Final order deadline issuing the settlement agreement of the no later than 90 days over the day of the cancellation. Conclusion of the hearing with the paragraph 2 with the Secretary of Labor shall issue the final order the providing final relief proposed prescribed by the paragraph of the providing denying the compliant with the time of the final order proceed with the subsection terminate with it on the basis of settlement agreement into the Secretary of Labor the complaint and the person alleged with the have committed violation be remedy response compliant with the file on paragraph 8(1) of the Secretary of Labor to determine the violation subsection A that is occurred with the Secretary of Labor shall order the persons who committed violation taking affirmative action to debate with the violation reinstatement of the complaint with the former position together with the compensation include back pay and then restore the term the item of privileges associated with his or her employment to provide with the compensationary damages complaint If such order is issued for the paragraph Secretary of Labor, the request of the complaint with the child again for the person again for the order within assumed equal for the aggregated amount of the cost and the expense with include with the attorney and expert witness fee for the reasonable incurred with the determine the Secretary of Labor the complaint with the connection with the bringing of the complaint with the time when the order is issued. Frivolous complaint Secretary of Labor to find with the complaint with the paragraph 1 frivolous and has been brought in bad faith. The Secretary of Labor demand war with the prevailing employer responsible attorney fee not exceeding $1,000. D no with a review of the general with respect to the compliant under paragraph 1 of the Secretary of Labor does not issue the final decision date that is 210 days after the date with which the complaint was filed with a delay when the time of the due with the bad faith of the employee with the was filed with the complaint with the employer may be bring with the original action law with equity with the D no with the review with the appropriate discretion. District Court of the United States will have the jurisdiction over the action without regard of the amount of controversy, which action shall the request of either part of the action tried by the court of the jury. The burdens of the proof of the clause. Original action described in the clause 1 shall govern the same legal burden of the proof of this paragraph specified in paragraph 2b with the review of the Secretary of Labor. For review, appeal of the courts of appeal to the effect of the any person effectively aggrieved with in order with the issue in paragraph 3 to obtain with the review of the United States of the courts of the appeal within circuit of the violation with the respect to the order of the issue, the alleged order of the circuit was if the complaint with resides in the day of such violation, the petition review of the maybe that must be filed with no later than 60 days of the day of the issuance. Final order. Secretary of Labor to review the shall conform with Chapter 7 and Title 5 of the U.S. Senate Code of the commencement of the proceeding with subparagraph unless the order of the court is operated with the state of that order. Being lateral limitation collateral attack, then order the Secretary of Labor with respect to the review which contained in the paragraph subparagraph A shall not subject the judicial review and criminal other civil proceedings. Emergency order of the Secretary of Labor when any of the person filed with comply with the order issued in the paragraph 3 of the Secretary of Labor in civil action under the United States of the District Court. District of the violation was found in the curve of the enforce such order of the actions under the paragraph of the District Court of the jurisdiction grant all appropriate relief, including but not limited to injunction relief of the compensatory damages. Enforcement orders as parties to commencement action under the person on behalf of the order of the issue in paragraph 3 commencement civil action any of the person under which is such over the request of the complaint with such over the appropriate in the United States District Court shall have the jurisdiction without regard to the amount of the controversy, the citizenship of the party of the enforcement of such order. Attorney of the court is issuing the final order of the paragraph of the make award cost of the litigation, including responsible attorney, expert witness fees, any part whenever the cost of the determined the such of the award is appropriate. Mandamus. Non-discretion of the duty of the imposed with the selection of the enforceable mandamus may proceed with the under section 1361 title 8. 1361, Title 28, United States Code. Non-applicable to deliberate violation, subsection A shall not apply with respect with any of the action employed with the employee who, without discretion, the employer shall employ with the agent deliberately cause for the violation of a requirement retaining the pipeline safety under the chapter any of the other law of the United States, non-enforcement, certain the provision, waiving rights and remedies requiring abatement, arbitration, and disputes. Waiver the rights of remedy. The rights and remedies provided in this section may not be waived by agreement in policy form, condition of the employment, including the pre-dispute arbitration agreement. Pre-dispute arbitration agreement is no provision of the dispute, but the arbitration agreement shall be valid, enforceable if the provisions require attribution of the dispute arising under subsection A1. 60130. Pipeline safety and information grants and committees.